taken into account by courts before sentence, and some require a detailed explanation by courts. It is well known that the ends of justice are four in number, being deterring, preventative, reformative, and retributive in its nature. It, however, consists of five important functions. It should act as a general deterrent. It should also act as a specific deterrent. It should also, or it must enable the possibility of correction. And it must be protective of society. And it must further also serve society's desire that crime be adequately addressed by courts. It is in the public interest that punishment be meted out fairly and without the measure of excessiveness that would mark it as being merciless and unacceptably unfair. The court is mindful that neither the call for true punishment and revenge, neither the cry for understanding must be given undue weight. The ends of justice, as mentioned already, must be given due regard when determining sentence. And it is required that a court should strive to accomplish and arrive at a judicious counterbalance between the elements mentioned and ensure that one element is not unduly accentuated at the expense or exclusion of any other element. It has been often stated in various case law that the sentence imposed should fit the offender as well as the crime. It must be fair to society and blended with a measure of mercy according to the circumstances of each matter. True mercy, therefore, has nothing in common with soft weakness or maudlin sympathy with the offender, since it is a crucial element of our justice system in its own right. It is also not an element that mere lip service is paid to, but indeed a sound factor that each court must consider and which must clearly reflect in the sentence imposed. However, courts are required not to strive as stated for severity, but neither on the other hand surrender to misplaced pity, and should not flinch from firmness where it is called for, and that a court should be strict enough to ensure that the objects of punishment are adequately furthered, and indicating thereby that crime will be effectively punished. Having said that, this court is well aware that a court should approach its task with a humane understanding of human behavior and frailties. Just a minute. I've been talking a lot, just a minute. I think at this stage, while we are still proceeding calmly, I'm going to deal with general concerns when reaching sentence regarding matters of this nature. Thereafter, the court will deal with the or reply to the offence before court or the matter before court. It should be noted that crime is inconsistent with the rule of law and the fundamental value of our Constitution. It undermines the constitutional commitment to human dignity and further the achievement of equality including the advancement of human rights and freedom, crime is therefore the antithesis of an open, accountable, democratic government as required by our Constitution. Chaskelson P. in South African Association of Personal Injury Lawyers versus Heath and others, 2001, SA 1883, Constitutional Court, 2001, in brackets 1, states that, I quote, elected office bearers and officials in the public service have become one of the most serious threats to our country's well-being, and that is to state the obvious. Although the mentioned case deals with corruption and crimes of dishonesty, it is still relevant to the crime in general, and as far as it relates to public office bearers, as the impact and consequence pertaining to the matter before court today remains the same, if not worse. It is clear that if crimes are allowed to go unchecked and unpunished, it poses a serious threat to our democratic state. Crime in South Africa is ever escalating, and it appears to be an acceptable way of life in our country, this being a situation of no violence, and that perpetrators of these offences are seen as not to be truly criminals or even prison material due to their ostensibly respectable careers and lifestyles. The above-mentioned case stated on record speaks about dishonesty. However, this court will dare to say that it does not merely refer to related offences such as fraud, etc., but it includes the dishonest character of an individual, indicating that such conduct entails gross breaches of trust. At the beginning of the sentence, the court mentioned the element of trust and that a court should consider before imposing a sentence, and based on the facts of the matter before court, including the circumstances in which the offences were committed, it shouts of the breach of trust and is of great concern to this court today. The accused is in a position of trust and elected as such by the members of society. The conduct of the accused and the effect of his actions and the impact of the conviction on the accused combined all reflects, contrary to what is expected from our Constitution, the complete absence of accountability and breach of trust by the accused person before court. Going to try and summarize the response to the defense submissions as follows. It must be noted, and the accused confirmed, that the event was planned. Emphasis on the word event was planned, and that it was a unique established tradition planning an event. Firstly, I stand corrected on this aspect, but what I should have clarified is the following, that this was, according to the knowledge of this court, the fifth birthday celebration was the first of its kind. I do not understand the wording of it was a well-established tradition. We heard that the 10th birthday celebration, what the main feature was, but whether it was an established tradition at the 5th birthday celebration, I'm not aware. As a result, it is a great concern to this court that an event was planned and that what appears to be the unique feature of the event ended up in the commission of an offense or offenses. Surely this can never ring true. As per the submissions, the court is asked to consider that the accused had planned the event, and then it goes a step further, because contrary to the view of the defense and the view of the state, today it is clear that the planning included that the accused will possess or take possession of a semi-automatic rifle, fire a .223 Remington bullet into the air, thereby causing possible harm to person or property in a built-up area. That it is now called a celebratory shots, that is sugarcoating. Nothing more, nothing less. The facts found by court during its judgment, and this is not merits, these are facts. I'm going from memory. It was the evidence considered was that the accused had decided that the event was planned by the leadership. All decisions were made by the leadership. So there can be no doubt that you are saying the unique feature of the event was committing 5 offenses. That is the bottom line. Clearly, planning of this nature is in contrast with the law. How can a court of law consider that the actions of the accused did not intend or did not entail the intention to commit an offense? It is not it is not the thinking of the court, it is the facts before court, because that is what happened. It wasn't, as the state correctly stated, an impulsive act. It wasn't, as a result of the case law we heard, an act of passion. It wasn't anger. It was the event of the evening. And therein lies the difference. It should take considerable planning for an event of that magnitude, and I'm deviating from my written judgment, of that magnitude, that as to how, when, and exactly at what time you will take possession of the firearm, where you will fire it from, at which point we all know then, Mr. Snyman, you returned the firearm to Mr. Snyman. That finding was made by court. The court did not find it was handed to you by Mr. Snyman. That is what I'll say in that regard. So that to reason any otherwise is nonsensical. This is a decision that a person made to possess a semi-automatic rifle unlawfully, and including the decision then to proceed and fire the said rifle in a built-up area in a crowded stadium. The decision to break the law has been made, and it was made with the approval of the accused person and the leadership. Since it's confirmed that this was the future planned for the event, It clearly indicates that the accused had known it was unlawful. He knew that it may cause harm to persons or property. He knew all the above, and it yet proceeded to possess the rifle and to fire the shot in celebration of the 5th birthday celebrations of the economic freedom fighters. Always knowing when this was being planned, arranging this special feature that it is in contravention of the law. And that this decision was made long before the actual event. Such acts can never be condoned by this court in any instance. The court cannot dismiss these actions planned by the accused as mere celebratory shots, and further justify the commission of crime under the pretense that it was celebratory shots. Much has been said yesterday regarding other offenders who've committed acts of this nature, worse, who have has not been brought before a court of law. This court is not in a position to answer for those matters. Safe to say, I trust that surely the long arm of the law would reach and bring those offenders or suspected offenders before court. This court can only reply and answer for the matter before it, not for what has been said was done by Mr. A to Z or Miss A to Z. I'm unable to do so. My focus is on this matter solely. With regards to yes, as I say, as far as it pertains to individuals who had committed the same offences and had not yet been brought before a court of law, should this type of reasoning be condoned, it is clearly not conducive to the interest of society, and the courts are required to act accordingly. And that is as much as I can say regarding the offenders who are still to be brought before courts. The other aspect that is aggravating in this matter and which needs to be mentioned is the astronomical financial impact this matter has had on the taxpayers' pockets or at the taxpayers' expenses. By saying that, please, that is not laid at the foot of the accused person solely, not at all. It was your right to take this matter on trial. I'm saying merely that a trial of this magnitude involved tremendous human or manpower. If we look at the ballistic side of this matter alone, the transport of firearms from KZN to Quebeca and back, the ballistic unit's resources and equipment, preparation, SAPs. The tragedy is that this matter has also led to so many people that did not have access to this court on several days where this matter proceeded. Mothers could not approach the court for maintenance. They could not reach inside. Grandmothers could not come to the offices to apply for foster care or guardians, appointment, adoptions, domestic violence. Those people did not have access. And that is tragic. These are members of the community this court services on a daily basis. They wake up, as you very well know, all of us very well know, by 3 a.m., by 4 p.m., those little kids are dressed, washed, and they walk to court. And yet they cannot reach the entrance of this court for the help that they need. What has transpired is indeed sad. It's a sad day for justice if this is what bringing a matter of this nature to court results in the impact on the interest of society. And as I've stated, the courts must protect the interest of society. Not only did it affect those people I've mentioned, courts adjourned early. Our court rolls are overcrowded beyond comprehension. Inmates had to be returned to correctional services, leading to the extension of the overcrowding of prisons or correctional facilities. Witnesses who traveled from far, who lost a family member, let us say in a murder incident, they did not get closure on a specific day which was allocated to them for their matter to be heard. They have to come back. So yes, this matter indeed is sad because it has an immense tragic effect on the administration of justice and the very interest of society that is to be served by justice and its staff and courts. And that is not overemphasizing, that is a fact and a reality. The only aspect I'll mention with regards to the time frame of the actual possession of the rifle, yes, indeed, I agree it was very short. I agree with the submissions of the defense that yes, the charge sheet mentions 1.223 Remington cartridge, correct. I agree that the charge sheet mentions 1 SPA 249. Therefore, the court is limited to what you have been charged for, and that is what I'm dealing with. Nothing more. Safe to say then, on what the court has already alluded to, the commission of these offences are not insignificant, and the impact thereof remains the same. Whether it was done in less than a minute, the impact remains the same. Now, this is a difficult matter to raise because it was alluded by the defense that should a custodial sentence be imposed by court, it will show that the accused is singled out to endure a harsh sentence. To this, the only reply from court is, it is not the court who has singled out the accused person. He had done so all by himself, not the court. In the light of the position that he holds as the CIC of a political party with massive support, it's not the court who had singled out the accused person. The fact and on this regard, I'll add the following, that please remember, it is not a political party who has been convicted here. It is not the economic freedom fighters that have been convicted. It is a person, an individual, who so happens to be the CIC of a political party. Nothing more, nothing less. It's not the party. It's an individual, and that is how it is perceived. And while I'm on the topic which is uncomfortable for everyone, let us continue with this political trend that is followed. This court heard, as I've stated, plus minus 19 witnesses. Not a single witness testified before this court testified regarding any political facts, or that is not facts before court. The evidence or political agenda was raised by the accused, which is your right, but those are not facts as part of the state's case. And that's where it ends. A court of law and members of society too enjoy rights, the same rights as enshrined in our Constitution. These rights are not one-sided and enjoyed by all. I'm about to end off. I just want to briefly refer to our engagement yesterday in the oral submissions by the state and the defense regarding the two case laws submitted, one by the defense and the other by Advocate Caesar. Just want to get to the relevant part. Yes. Okay. The matter submitted by the state being Romeo Janssen and the state, case number CANR 220/18, delivered by D. Van Zyl, then DJP, and by the defense, that of the Malundana case, case number CC20 2024, delivered by Brooks J. Now, in this instance, it was interesting to read both. And what is abundantly clear is that in the matter presented, the Malundana case, the facts are completely opposite as the ones we are dealing with today. In the matter submitted, the Malundana matter, was a gentleman of 62 years old who had, after a very long period of time, secured employment as a security officer protecting a school, which led to him firing a handmade firearm. The difference in that matter, which the judges considered as sentence and mitigation of sentence, is the accused there had pleaded guilty. He had also spent a period of time incarcerated, 4 months in custody before. Further, he was also a first offender. He had assisted the victims at the scene, and he himself had called the police to come and assist. He had also contributed to the costs of the family who suffered in the incident. That is the set of facts unique to that matter. Now, what is interesting in the Janssen matter Counsel argued yesterday that the matter cannot be of assistance to the court. I disagree on that aspect. Indeed it was. Because I think it was said that he had previous convictions, Janssen. But when you read the actual judgment, the judge states clearly that the accused was treated as a first offender despite having previous convictions. So that is not relevant. That was, he said, and he was found to be, or having been in possession only. There wasn't a crime that was committed on the day he was arrested with the firearm. And then interestingly, after being asked by the defense that all people be treated equal, it was submitted that Janssen is a gangster, therefore a member of Fat Boys, and therefore sentence of custodial sentence is in order. I failed to see the reasoning and the rationale behind that, but what is evident and clear after discussion of all the cases submitted by the state and the defense, in the view of this court, each case is unique. Every person is equal in law. What does equal mean in my view? That the court should ensure that accused rights to a fair trial is protected and that it applies equally to every individual who appears before a court of law. Sentences, we have this contradiction and variety because, as I've stated, each set of circumstances and facts are unique. If we take, without disrespecting a gangster, we cannot say for gangsters, right, there's a sentence of 5 years. For politicians, it should be 6 years. For the homeless person, it's 10 years. No. It's done in its totality. And unfortunately, the accountability on a public office bearer is a lot more. It weighs heavy than that of the regular South African person. So by saying that, that doesn't mean you are not treated equally or the accused is not treated equally. That is not what equality, in my view, entails. I'll end it shortly. There we go.